Friends, I welcome you all to lecture number 3 of Family Law. This is a part of Clat lecture series sponsored by Sri Jendra Zone. I'm your mentor, Shekhar Gehlot. Okay, so we are now discussing family law and various types of issues which may pertain to a family law. Okay, various type of problem solving as well, such as there may be issues regarding marriage, issues regarding Hinduism, issues regarding adoption. Okay, so now in continuation of that series, we will discuss the maintenance. We will discuss the maintenance. So the key question first, which we have to understand is what is what is meant by maintenance. Okay. Uh, See, first of all, we must understand the term maintenance is a very complex term. Okay, mostly many terms in the law which you will get familiar with are complex in law. Okay, it is very difficult to define them. And we can only try to understand those things, but we cannot fully define something. We can understand it, but we cannot define it. Okay, so maintenance is also one such term which is very complex to understand. So maintenance, generally we can say, by maintenance we mean funding of the necessities of the life. Okay, now what are the necessities of life? What are necessities of life? It depends upon status of parties, age of parties, living standard, community standard, etc. Okay, maintenance can depend upon a number of factors. It can depend upon the status of parties. What is the state of parties? Okay, what maintenance money I will give to my wife will definitely be different than a maintenance money which a superstar will give, or Virat Kohli will give, or Mukesh Ambani will give. And it shall also be at the same time different than what a poor person will give. Okay, because see, I fall in the middle income group family. So, lower income group family will have a different kind of maintenance. Age of the parties. What is the age of the party? Okay, if the wife is very old, she will be having more of the medicinal expenses rather than lifestyle expenses. If she is young, she'll take a lot of lifestyle expenses. Okay, so it will depend upon that as well. Living standard. What is the living standard of both the parties? Okay, and what is the living standard of husband? Okay, husband or the father. It cannot be the case that husband is living a luxurious life. Okay, it cannot be that husband is himself spending 3 lakhs a month and he is giving just 20,000 to wife and children. Okay, he must give something else. It all depends upon how much husband is earning and how much he is spending. it is also one of the factors. Community standard. Okay, what is the standard of the living of the community in which wife and children are living? Okay, so these are some considerations like education of the parties, etc. Okay, these are all standards or variables upon which court will decide what is to be the amount of maintenance. Okay, so maintenance cannot be defined, but maintenance is funding. Maintenance is funding. So definitely we so maintenance is defined in terms of money or things which can be valued in money only. Okay, so love and affection is no maintenance. I love my wife, I love my children. That is sufficient maintenance for them. No, that is not the way you maintain someone. Maintenance we are talking about living, and living requires expenses. It requires assets as well. Okay, so maintenance is defined always in terms of money. Okay, that 20,000 rupees per month, 40,000 rupees per month, 8,000 rupees per month, or things which can be valued in money only, like one house and 20,000 rupees per month, one house, one car, and 10,000 rupees per month, like these. Okay, so it is very complex term, but always it is decided in terms of money alone. So this is what is maintenance. Okay, our traditional Hindu law, it says that a husband or a father, as the case may be, has a pious obligation. Pious means religious obligation, godly duty, okay, purity, duty of purity. He has a godly duty, duty given by the God, given by the directly from heaven, to maintain his wife as well as his children. Okay, this is our traditional Hindu law. So now, by making a law on maintenance, we are just trying to take forward this traditional concept of Hindu law, plus we are trying to make it more uniform and more certain that what should be the Hindu law. We are trying to make it more uniform and more certain. Categories of people eligible for maintenance under Hindu Adoption and Maintenance Act. Okay, HAMA here stands for Hindu Adoption and Maintenance Act. These are the categories of people who are eligible to take maintenance: wife, widowed daughter-in-law, wife of a son who has died, widowed daughter-in-law. Aged parents. Parents are also entitled to maintenance, and that's a very beautiful feature of Hindu law. It does not leave any person outside the purview of maintenance. It says you have to maintain wife, you have to maintain a daughter-in-law as well. You marry your son, you bring a daughter-in-law, and now your son has died. And now who will maintain this lady? If your son was alive, your son was duty bound to maintain her. But now your son is dead, so who will maintain her? You will maintain her. Okay, the father-in-law will maintain daughter-in-law as well. And aged parents. Your parents have become old, they are infirm, they are not as capable or energetic as they were when they were young. So now it is upon you to maintain them because they maintained you when you were in the infancy or young. Now let us understand maintenance to different people. Maintenance to wife. A Hindu wife is entitled to be provided for by a Hindu wife is entitled to be provided for by her husband throughout the duration of her lifetime as per section 18 of Hindu Adoption and Maintenance Act. Husband will maintain her throughout the life. Okay, it's a life bound on duty. It's a life bound on duty and husband cannot escape it. He has to maintain the wife throughout the life. Maintenance will apply even if wife is living separately from husband. Okay, he'll have to pay maintenance even if the wife is living separately from husband. Okay, deliberately. But no maintenance shall be provided to a wife who is living away from the husband without justified reasons. Okay, so Hindu law is putting a lot of emphasis on reasoning. Okay, we put a lot of emphasis on our actions and the reason for such actions. Okay, that is why in the criminal law as well we were like actus law and actus law and mens rea, because we are putting a lot of stress on what should be the case, what should be the crime, how a crime has to be committed. This is how we get our things, that mens rea plus actus rea. Grounds of living separately are, okay, but if a woman, but if a woman is staying away from husband due to bona fide and just reasons, then she shall be entitled to maintenance from husband. In such cases, maintenance cannot be denied to her. Now, what are the grounds of living separately with the wife? On what grounds a wife can live separately from husband? Let us see. Husband has deserted the wife. Now we have known what is desertion. That you have left the spouse alone. Okay, without any reason you have left the spouse. Okay, without any justified reason, one spouse has left the company of the other spouse. And marriage, what is the value of marriage when you are not living together? Marriage is only a union. If you are not following that union, what is that marriage? So if other spouse, husband has deserted the wife, husband has left the company of wife without any justified reason. So now in this case, even though wife is living separately from husband, then also she'll get maintenance. Husband has another wife living. Okay, husband is keeping another wife. Husband has married, or he was already married. Okay, he was already married when this wife entered his life, or he married another wife after this wife. So, in such case, a wife is entitled to stay away. Law says if your husband has got another wife, then you are entitled to stay away and shall claim maintenance as well at the same time. Husband keeps a concubine in her house and habitually resides with a concubine elsewhere. Now, in clause 2, husband has brought a wife. He has married a lady and brought her. But here he is living with a lady whom he has not married. Okay, whom he is not married. Okay, he keeps a concubine in the house. That lady is called concubine. He keeps a concubine in house, or he habitually resides with a concubine elsewhere. This concubine is living somewhere else, and husband habitually keeps on going there, like 15 days a month or 20 days a month or 4 times a week he'll go and stay there. So if husband is in such a behavior, then also the wife is justified to leave the company of the husband. Okay, and she shall not be denied maintenance on the ground that she has left the company of the husband. In such case, she is validly allowed to leave the husband as well as to claim maintenance. Husband has converted to a different religion other than Hinduism. Okay, you marry a person who is a Hindu. You are also a Hindu. So you marry a husband who is a Hindu, but later on he says, I'll become a Muslim, I'll become a Christian. So this is a violation of the condition of the marriage. Okay, this is a kind of violation of the marriage. You had married a Hindu, you wanted a Hindu husband only. If somebody would have wanted a Christian or Muslim husband, she would have married a Muslim or Christian, isn't it? So now you are turning someone else. So this is not agreeable to the wife. Then what can wife do in such a case? And husband is not listening. He says, no, I'll turn Muslim or I'll turn Christian. What can a wife do? Wife can, like we discussed, it is also a ground for divorce. Wife can take a divorce on this ground, as well as if wife wants, she may not take the divorce, but she may just start living away from the husband, and she will keep getting maintenance as well. Husband exhibits cruelty. Okay, husband is habitual of exhibiting or administering cruelty. Okay, treating her with cruelty. Now, what is cruelty? We have discussed in the previous chapters. It is both a physical as well as a mental act. Okay, that means cruelty can be conducted by physical actions. Physically, you are beating someone, or you can mentally also harass someone. You can have cruelty on someone mentally as well. Like we can take an example. Husband keeps on doubting over wife and keeps telling her that she is cheating on him. She's cheating on him, she's having an affair outside. Show me your phone, I'll show your books, I'll show your checkbook, I'll show your email, give me this and that. Okay, he's always after the woman, and woman is not indulging into any such behavior. So she definitely will be outraged, and this will definitely amount to cruelty. Okay, that you are committing mental cruelty. He's not beating her or he's not touching her physically anywhere, but he is committing mental harassment, and that is a mental cruelty. Now if husband is doing so, then in such case wife can definitely stay away. Okay, cruelty cannot be defined. This is one instance. I'm just trying to make you understand what is or what can be mental cruelty, but it can be anything. He's constantly okay, he's alcoholic, he's playing, he's gambling, he's constantly abusing her and abusing her family as well. Okay, so though nothing happening is physically, but he is guilty of committing a mental cruelty. Okay, so we cannot define cruelty, but we can only understand that what a cruelty can be. Husband has virulent case of leprosy. Now we have discussed virulent means severe. Virulent is severe and contagious. Something which is severe and contagious, it is called virulent. Okay, which means he has leprosy, and that kind of leprosy which will now spread to other person, whoever will come into contact with the husband. So now she has a right to stay away, because definitely everyone has a right to maintain their health. Section 125 of CRPC also makes it mandatory for husband to provide maintenance to their wife. Okay. Section 125 of CRPC. Okay, we have a CRPC. CRPC stands for Criminal Procedure Code. Okay, it has a section 125 of it. Okay, section 125 which says if any person who has sufficient means okay, it says I'm not reproducing the whole section here. Okay, the whole section is very lengthy. It may take up 1 to 2 pages. Okay, so even the whole wording of the section it is not required for you people at this present stage of time. So you can just understand the gist of the section criminal procedure code. Okay, it is a procedure we follow in the criminal cases. So it says that it is also a criminal act if you are not maintaining your husband, sorry, your wife, children, or parents. Anyone who has sufficient means and refuses to maintain, okay, he is guilty. Now, what is sufficient means? Nobody knows what is a sufficient means. Just like maintenance, sufficient means will depend upon various circumstances. But if someone does not have sufficient means, then also he will be liable to maintain wife and children and parents. So if someone does not have a sufficient means, he is not having much money, then can he say that I will not maintain my children or my wife? Can he say so? No, he cannot say so. Law says even if you don't have sufficient means for yourself, then also you have to maintain her and the children. Okay, how you maintain? You commit a crime, you earn, you sell your body, whatever you do, but you have to do it. Okay. Now, law obviously does not say you to commit crime, but ultimately it is that you have to maintain. Either way, you find work, whatever you do, a labor job, you do a gardener job, whatever job you can do because you are physically fit and you have a duty, you have to discharge the duty. However, as per section 125 1A, wife is eligible for maintenance allowance only when she is unable to maintain herself. But this section says only if wife is unable to maintain herself, then only she will get the maintenance, not because merely because she is wife. She is a wife. And suppose so if a wife is earning more than the husband, then in such a case, definitely wife is not entitled to take maintenance. Why? Because it is writ large, she is sufficient to maintain herself as well as she is earning more than the husband. Okay. Or even if she is substantially earning, then also she cannot compel the husband to pay maintenance. Okay. The provision of maintenance is only for sustenance and not for luxury. Okay, that we talk about maintenance only for sustenance. That if maintenance is not provided, wife will die, children will be on the street, and something like this. They have no means to maintain at all. But it is not luxury that some wife will say that I want to buy a car, then he should give me money. I want to buy an expensive suit, he should give me money. No, this is not the kind of maintenance we are talking. Since similarly, if a wife is herself earning, she is able to maintain herself, then she simply says, because I am earning, wife is earning 1 lakh, husband is earning 5 lakhs. Simply because wife is earning 1 lakh and husband is earning 5 lakhs, she is not entitled to take extra 50 60,000 from husband. This is not the case. We are not promoting worklessness, joblessness, or the luxury nature, and maintenance is only for maintaining. Okay, so whatever is required, and it cannot be defined, it can only be understood in the case to case basis. The onus is on the wife to establish that she requires maintenance. Onus means it is a duty of the wife that she has to prove in the court that I want maintenance. Okay, in such cases. In addition, maintenance can be annulled if not applicable. Okay, maintenance can be annulled. Okay, maintenance can be annulled means maintenance can be denied as well. Wife could be denied maintenance. In what cases a wife could be legally denied maintenance by a court of law? Okay, let us see that. First situation is wife renounces being a Hindu and converts to a different religion. Now I have married a Hindu wife. Okay, I married a Hindu wife because I'm a Hindu and I follow a Hindu religion. I believe in the Hindu tradition. So I got a wife who's Hindu. But now she has turned Muslim, or now she says I want to become a Christian. So in such scenario, if I wanted a wife who is a Muslim or Christian, I would have married a Muslim or Christian, isn't it? So when my wife, who was Hindu, and I married her as a Hindu, and now she is turning to some other religion, that is a kind of cheating. Okay, that is a kind of fraud committed upon me. So if a wife is becoming Hindu or converting to some other religion without my permission, in such cases, wife can be legally denied maintenance. Okay, wife can be legally denied maintenance. She commits adultery. Section 125 for CRPC also confirms likewise. So she is committing adultery. Adultery means she is living with another man. Okay, she is living with another man, or she is having physical relationship with any man outside her marriage. Then she is said to be committing adultery. So if she is living in adultery, then HAMA, Hindu Adoption and Maintenance Act, this says she is not entitled to get any maintenance at all. Plus even section 125 of CRPC, it says then she is also not allowed to take maintenance. Even in CRPC she is not allowed to take maintenance. Even in HAMA she is not allowed to take maintenance. Okay. Now there may be a question to your mind that how many maintenance will a wife get? So a wife or children can get maintenance under these three acts: Hindu Marriage Act, Hindu Marriage and Adoption Act, Adoption and Maintenance Act, Section 125 of CRPC. Now wife can file a case in this section as well, in this section as well, in this section as well. Okay, but it doesn't mean that she'll get three maintenances. Okay, that she will get three maintenances. It is that all these three cases will consider the amount. Suppose section 125 court, it comes to a prior decision. It says that husband should pay 8,000 rupees. Okay, and the court which is dealing with this application, it says 8,000 is sufficient and it has already been awarded, so it won't award anything. Hindu Marriage Act, this court feels that 10,000 should be given, so it will say 125 CRPC court has already granted her 8,000 maintenance. Now balance 2,000 you shall pay. You shall pay now 10,000, total 10,000, 8 plus 2. It is not they that they will give 8, this will give another 10, and this will give another 8. So ultimately maintenance is going to be 40,000. No, this cannot happen. They will all consider each other's decision as well while granting maintenance. Okay, but wife has been given option to proceed in either section or all of them. Okay, but all courts will confirm with each other. If wife refuses to live with husband without sufficient reason. Now, if wife refuses to live with the husband without sufficient reason, now what is a sufficient reason for the wife to stay away from the husband? Now, these are the sufficient reason which we discussed. If wife is living away from husband and there is no case fulfilled, okay, within these six categories, then her living separately from the husband would ultimately be illegal. Okay, so if she is refusing to live with the husband without a sufficient reason, she is not allowed to take maintenance. Okay, this is just a reproduction. Okay, this is just a reproduction of what we have discussed. If wife lives separately with mutual consent, living separately owing to divorce is not a mutual consent. Okay, so if wife is living separately due to mutual consent, okay, they are having a mutual consent, husband and wife, they agree that they shall live separate from each other, they are giving a break to their relationship or something like this, okay, like they show in the movies. Then in such cases she will not be entitled to take maintenance because she is not supposed to stay away from husband, so she is not entitled to take maintenance in such cases. Wife relinquishes right to maintenance voluntarily. Wife herself says I don't want maintenance. Wife can do so. Okay, we have our rights and we can choose to exercise those rights and may choose to altogether give up them as well. It all depends upon us. Okay, law will never compel us to exercise our rights. Law can only assist us if in case we want to exercise our rights, but if we do not wish to exercise our rights, law cannot come and automatically ultimately help us. So if wife does not want maintenance, okay, let's not have it. Maintenance of daughter-in-law. Okay, now we come to maintenance of daughter-in-law. If the wife is widowed by her late husband, okay, if the wife has become widow due to the death of her late husband and has no other means of providing for herself from the estate of her husband, okay, she has no other means of providing herself from the estate of her husband, okay, father or mother or from her son or daughter, the father-in-law. Now she has no means to provide for maintenance from husband's estate or father or mother, her father or mother, her father or mother, not father-in-law or mother-in-law. Her father or mother are not able to maintain her, or her son or daughter is also not able to maintain her. Then the father-in-law has to provide the maintenance from the joint family property. Okay, father-in-law shall, in this case, maintain the daughter-in-law whose husband has died. This provision holds until the widow remarries. Okay. If from these three categories, if a widow, daughter-in-law, is unable to maintain herself from the property of her husband who has died, from her own mother, father, from her own son, daughter, then it shall be the duty of father-in-law to maintain her. Okay, it shall be duty of father-in-law to maintain her. But if she conducts another marriage, if she remarries, this duty of father-in-law will come to an end. Okay, he has to maintain her till the time she does not remarry. Father-in-law Father-in-law is not liable if the share of the deceased husband in joint property is already shared and allotted to the widow. Further, okay, father-in-law is duty bound to maintain her only if they are living in a joint family and father-in-law is holding control of the joint family property. Okay, then he shall pay maintenance to daughter-in-law. Why? Because she also has a right in the joint family property because she will survive her husband. Okay, she will get the property which her husband is supposed to get, but still the joint family is joint property is not divided. So her husband's property that is now her property is also a part of joint family. So whatever income is being generated from joint family, she also has a portion in it. But if the share is already allotted, okay, if the share is already divided and given to her or her husband, then she cannot claim such from the father-in-law. Now the father-in-law's duty will come to an end upon her remarriage or allotment of her share from the joint family property. Maintenance of children. Hindu Adoption and Maintenance Act obliges parents to provide maintenance for their legitimate and illegitimate children. Now, parents are liable to provide maintenance to whom? Illegitimate children born outside marriage. Okay, legitimate children is those who are born from the marriage. Illegitimate are those who are born outside the marriage. For boys, in case of a boy, until they become major, that is 18 years of age. 18 years of age. Okay, then they shall. Okay, but here until they become major. Until they become major means if a boy. Okay, that for a healthy boy till the age of 18, parents are liable to maintain a child that is a male child only till the age of 18 if the child is healthy. After 18, he cannot force his parents to maintain him. If parents do not wish to maintain him, then he shall find his own house, find his own occupation, do whatever he wants to do it all himself. Okay, only till the time he attains majority. Parents are liable to maintain him, but a person who is unsound mind is considered to be minor throughout the life or till the time he doesn't become sound. So if the minor is there, okay, if some male child he is unsound mind, okay, then he'll have to be taken care of for the whole lifetime. And for the girl children, okay, now for the boy is 18 years and for the girl until they are married, till the time the girls are married, okay. If a girl is unmarried, she is 30 years old, then also parents are liable to maintain her because there is no age gap given here. Okay, it is that girl shall be maintained by the parents till the time she is not married. Inform daughters unless until they are able to take care of themselves. Okay, like if daughter is not married or daughter is informed, just like the case of mentally unsound. Maintenance of parents and other dependents. Okay, now there were four classes, isn't it? We discussed four classes: wife, widow, daughter-in-law, aged parents, and other dependents. Given in section 21 of the Act. Other dependents. Now, what are these other dependents? Let us see the other dependents. Maintenance of parents and the other dependents. HAMA Hindu Adoption and Maintenance Act obliges a person to maintain his or her dependents. Dependents include, okay, Now, Maintenance Act says that a person is obliged to maintain his or her dependents. Her dependents means even a woman is now liable to maintain. Okay, aged and infirm parents. Okay, aged and infirm parents. Now, what is aged? What is which age we call people aged? Okay, let us say above 60. Above 60 years and infirm. Infirm does not mean they should be bedridden. Okay, if they are more than 60 years, they are ultimately understood to be infirm. They are not capable, just as a usual person is, as a young person is. Okay, so they are considered infirm. Okay, so we are having two brackets here. One is aged and infirm. If the parent is above 60, he shall have maintenance. Or if the parent is not above 60 but infirm, okay, then also a parent can have right to seek maintenance from the child. Child is child. Child cannot have any gender for the parents. Child is child. It can be boy, it can be girl. So in both cases, it may be a man or it may be a woman, they are entitled, sorry, not entitled, they are liable to maintain their aged and infirm parents. Legitimate and illegitimate minor child, both male and female. Okay, so whatever legitimate and illegitimate minor children are there. Okay, minor means now below 18. They are there, both male and as well as female. Okay, you have to maintain both the children. Now, even a woman is liable to maintain children. Okay, so is a woman is also liable to maintain children. Unmarried daughters who are not minors, like we discussed, girls have to be maintained till the time they do not get married. Okay, even if they are not minors anymore, even if they have turned into adulthood but they are not married, then you shall be entitled, you shall be liable, parents shall be liable to maintain such daughter. Widowed daughter who does not get maintenance from her husband estate, son or daughter or father-in-law. A daughter who has become widow, okay, but she has no means of maintaining herself, either from her husband's property, or her son is not maintaining her, daughter is not maintaining her, or even the father-in-law is not maintaining her. Okay, father-in-law will not maintain her if father-in-law has given the share of the property to her. Now after the property as well, she is not unable to maintain, she is not able to maintain. In such case, her parents, her mother and father, are liable to maintain a daughter who is a widowed daughter. Okay, son and unmarried daughter of a predeceased son. Son and daughter of son who has died. Simply we can say grandchildren. Okay, your son has died, but your grandchildren are alive. So a grandfather is duty bound to maintain grandchildren. Okay, a grandfather is duty bound to maintain grandchildren. When it comes to grandchildren, the grandson till the time he attains 18 years of age, and granddaughter till the time she is not married. Okay, so granddaughter has to be maintained by the grandfather or grandmother till the time she is not married, and grandson has to be maintained till the time he turns adult. And son and an unmarried daughter of a son of a predeceased son, as long as they are minors and do not get maintenance from their parents' estate. Now, son and unmarried daughter of predeceased son, they are grandson. Son and unmarried daughter of a son of a predeceased son, that is great grandchildren. If you live that long and you have great grandchildren who are not able to maintain themselves because your grandson has died, or your son or your grandson both have died, no one is there to maintain themselves, then if such is the case, that in such unfortunate situation that great grandson and children, great grandchildren are there and great grandfathers are there, but there is no one in between. So ultimately, because great grandfather, however old great grandfather or great grandparents may be, because they are more sound, they have to maintain the great grandchildren. Till when? A male till the time he turns 18, female till the time she is not married. Widow of a son of a son of a predeceased son. Widow of a son or a son of a predeceased son. Okay, widow of a son means daughter-in-law or son of a predeceased son, grandson, as long as she does not remarry and she does not get maintenance from any source. Okay, widow, your daughter-in-law or your daughter-in-law or the wife of your grandson. Okay, your son's wife or your grandson's wife, you have to maintain her. Okay, and the maintenance of her will definitely be till the time she does not have the property from the family or till the time she does not remarry. The obligation extends if parents and unmarried daughters are unable to maintain himself or herself out of his or her own earnings of the property. Okay, the heirs of deceased Hindu are bound to maintain the dependents of the deceased out of the estate inherited by them from the deceased. The liability of each person who takes the estate shall be in proportion to the value of the share or part of the estate taken by him or her. Okay. So whatever estate you are taking, suppose someone is dying, he is leaving some property behind. So whoever is taking that property, whoever is getting that property, he must maintain the other relatives of the person who has died, like father, mother, and so on. Okay, whoever is taking the share in the property will maintain the other people which the father was liable to maintain. Okay, which the father was liable to maintain. Now, what could be the amount of maintenance? Amount of maintenance. The amount of maintenance in all cases is left to the discretion of the courts. Discretion of the courts means whatever seems or appears reasonable to the court. That is the discretion of the court, option of the court. The factors which are considered while fixing the amount of maintenance, what factors a court could consider? Position or status of the parties, number of person entitled to maintenance. Suppose now, so see how many people a male has to maintain. So now he's maintaining all these three, and wife has filed a case of maintenance. So while deciding what maintenance should be given to wife, court will take into consideration that he is already maintaining a children, parents, and grandparents. Okay, so we cannot set the amount of maintenance in favor of wife so much that when money goes to her, these people are unable to feed. Okay, so we have to make a balance between all the categories of people who are entitled to seek maintenance. Reasonable wants of claimants. Generally, maintenance means appropriate food, clothing, and lodging. Okay, reasonable wants of the claimant. Reasonable wants only will be satisfied. We discussed it is not. It is for sustenance and not for luxury. Maintenance is sustenance, not luxury. Whether the claimant is living separately or with the parents or husband. Okay, if the claimant, suppose the wife, she is living separately, she'll get some extra maintenance, or if she is living with her parents, because even parents are duty bound to maintain their children, isn't it? Even parents are duty bound to maintain their children. Then in such case, the maintenance should be such. Okay, it will depend upon the case to case basis. If she is living separately, husband will have to pay higher amount. If she is living with the parents, then in that case, husband may not be burdened with a great amount, because even parents are entitled to maintain. So when she is living with parents, definitely she can seek maintenance from parents as well. Value of the claimant's estate and income. Okay, what is the status, what is the estate, what is the property, what is the income? Okay, how much? Suppose wife is claiming. Now what is the estate, what is the property with the wife, or what is the income of the wife? If she's earning at all, if she is having any property at all, what is value of what is market value of all these things, while finding the amount of maintenance she will get. So the part of maintenance is complete. Next chapter we will begin with adoption.